Um, the interview will be by all of us 9 commissioners. And at this point, Judge, I would like the commissioners to introduce themselves, and I will start. And my name is Professor Olive Mugenda, Commissioner representing the public. Thank you. To my right.
Good morning, my Lord Judge.
Good morning.
I am Philomena Mbetemwilo, the elected representative of the Supreme Court to the Judicial Service Commission and the Deputy Chief Justice of the Republic of Kenya.
Thank you.
Good morning, Judge.
Good morning.
I'm Patrick Gishohi, representing Public Service.
We thank you.
Good morning, my Lord.
Good morning, sir.
I am David Majanja, Judge of the High Court and male representative elected by the Kenya Magistrates and Judges Association.
A big pleasure, my Lord.
Good morning, my Lord.
Good morning, sir. Sorry. Good morning.
I'm Oluwande Evelyn. I'm a Chief Magistrate, the female representative of KMJA. You're welcome.
A big pleasure. This should be our first meeting.
Yes, my Lord.
Welcome.
My Lord, good morning. My name is Machari Anjero. I represent the Law Society of Kenya.
Oh, thank you, sir.
Good morning, Judge. My name is Felix Koske. I represent the public.
It's a big pleasure, and thank you.
Morning, Judge. My name is Mohammed Warsame. Welcome once again.
Asante sana. Thank you, and thank you again.
Very good morning, my Lord. Kehara Kariuki. I am the Attorney General, and I'm a member of the Commission by virtue of my office.
Thank you, sir.
Thank you very much, Honorable Judge. We will break after 2 hours, Judge, but if you need a break before that, you can kindly let me know, and then we'll have that break.
Thank you.
So, Judge, I will start off the interview, and I would like you to briefly tell us about yourself, your career, maybe 2-3 minutes, your honor. Please go ahead.
Thank you, Gautier. My name is D.K. Njagi Marete. No additives, no subtractions, no additives. And the authority for that name is the Registration of Persons Act, Chapter 107 of the laws of Kenya. Of late, I've been receiving various baptism by my employer, 5 months later by the Chief Justice Emeritus. In 2012, when I was appointed a judge of the Employment Court, the press put my name as D.K. Jambi Marete. Well, I'll go by what you say because I lived in the 60s as a boy, in the 70s, and I know the danger of protesting a nickname or anonym. Thank you. D.K. Njagi Marete was born 61 years ago. We attended various schools, starting with the Kirege Primary School at some place called Chuka in Tharaka Nithi County, Alliance High School between 1974 and 1977, Meru High School 1978 and 9, the University of Nairobi between 1980 and 84, the Kenya School of Law in 1984-85, clearing on the 31st of July 1985. On academics, thereafter I went to work at the Attorney General's chambers. I did 17 years and 65 days at the Attorney General's chambers. Rising from State Council 2, we started as a legal assistants, but activated so that we also got the title of State Council, which appeared like it was privileged. So in 2002, I left the Aegis Chambers and I went to buy for a place, member for NIFI, which was unsuccessful. In 2003, very early 2003, when the whole country was in a very celebratory mood, I came back to Nairobi, very empty-handed, and I started a small practice about 100 meters from where we are seated, and lasted 11 months. In November, 23rd of November that year, I joined the Teacher Service Commission as the senior principal legal officer, and lasted 5 years and 40 days. On that, 70 days, on the 70th day, I was issued with a letter of retirement on public interest, and I made a departure to my home at Ongata Rongai. We started a practice at Ongata Rongai this time, which lasted 3 years, and in that 3 years, we also combined it with teaching in 2012 at the African Nazarene University. In that time, my days at the TSC, I had also done my master's program at the University of Nairobi, LLM. And earlier on, I had done a diploma in theology through the Presbyterian University of East Africa, or the Presbyterian College then. And that is who I am in terms of academics, and in terms of history of work. On the 12th of December, not December, but July, I was appointed a judge of the Employment and Labor Relations Court, which place I sit to date. Thank you. Good chair.
Thank you very much, Your Honor. Your Honor, why do you feel that you are the best qualified candidate to be our next CJ?
One, I know myself. I know my abilities, and they have been tested. Right from the day one, work-wise, at Sharia House, the Department of the Registrar General, on the from 1st of August, 1985, to January 1987, 1.5 years, I was a celebrity at Sharia House in terms of performance, in terms of meeting the requirements and the happiness of the people of Kenya. And when I was transferred to Nyeri in January 1985, there was like a riot on the corridors of the third floor, the public trustee. When you send him away, who will serve our interests? Who will serve us in this scale? Throughout my career, Nyeri 8 years, come back to Nairobi in 1974, the same assignment, did another 8 years. The Teacher Service Commission, the judiciary, it is shiny. It is shiny, and anybody who walks around me can testify to that extent. That and my other abilities makes me the most suitable candidate for this kind of adventurous assignment, the Chief Justice of the Republic of Kenya.
Thank you very much, Your Honor. That question is, as you know, Judge, leadership is key to the transformation of institutions. So I want you to tell the Commission specific achievements, that can be attributed to your leadership in your career.
I have not sat in a big office like you had. I sat in Sharia House 1.5 years. I sat in Nyeri 8 years in the Department of the Registrar General and later Administrator General. I came back to Nairobi in 1994, did another 8 years, left, went to some private practice of some kind. I went to the Teacher Service Commission. Look at my track record. The best I could have done in that circumstances is head a station in Nyeri, head a division in the Teacher Service Commission, teach at the African Nazarene University, manage myself at in my various fora of private practice. And the success story in that, you cannot succeed if you are not very organized, if you are not very focused. My hallmark is that one, is a good leadership. I put that very, very clearly in my self-assessment, and all those attributes which you find in my self-assessment tell you that I am good to go. I am very, very good material for this kind of assignment. 2, daring is my other name. There is nothing which shakes me. This office requires a very, very daring person, a person who doesn't antagonize anybody, but will be able to work with anybody and resist anybody who comes in to fool around with the office and the entire establishment, the judiciary as such. So we have qualities, personal attributes, which very much tell the story of our abilities, our performance, our leadership strategies, our leadership abilities, etc., etc. We are saying that we are capable, we are able, we can organize this team called the judiciary to excellence in several senses of the word.
Thank you, Your Honor. My last question is, I'm sure you must have thought about your vision for judiciary when you applied for the job. So what is that vision, Judge?
I am a result-oriented leader. What ails the judiciary from the onset is the backlog of cases. I have a history where I don't live with backlog. I have a history where I was able to do 47 judgments and rulings in a month, in December 2017. I would sell this to everybody else who works in the judiciary, both the judicial officers and our other staff, so that we are able to transform to workers and people who have the interests of the country at heart, and be able to clear this backlog in the next 1095 and 3/4 days. And that is doable if everybody looked at himself as a Kenyan, looked at the issues Kenyans have, and wanted to address them. That is very, very doable in the next 3 years, and I would do that. If I am not able to do that in the 3rd year, I'll be able to take account and say we failed, and answer to Kenya and to my people in the judiciary, and tell them we have failed because of A, B, C, D, and E. And in any case, I would even see the developments in the course of time and work on those developments. The issue of failure, the issue of inadequacies, and clear those, so that in 3 years, Kenya will be free. And you bring your matter in 365 days, you have the matter cleared. We release everybody to go and do their things. How would we be able to do this? Capture 2 main stakeholders. One is the workers, the staff of the judiciary. And when you do that and motivate them, make them happy, they were awarded tea and water by the Chief Justice Emeritus, Chief Justice Mutunga. Give them a ban or 2, motivate them, work with them. I work with everybody from a standpoint of equality. Sit with these people, whatever their status, whatever their rank. Teach them, consult them, work with them. This is doable. And I'll repeat that 1,000 times. It is doable, and I'm capable of doing it. The other stakeholder is the people of Kenya, and the people of Kenya must also be pleased and made to join us in the struggle to clear our effects. A backlog is not a causative of the judiciary alone. We have our other stakeholders. There is the Law Society of Kenya. There is the people of Kenya, which is the mainstay of the litigants. What you do is capture the people of Kenya as a second stakeholder. Please them, work such that everybody who comes to court leaves with a smile. And I've achieved that. I see it even in this time of Teams. Over the screen, everybody who leaves my court leaves happy. If you sell this to the people, to the workers of the judiciary, and every Kenyan came here and left happy. Every time they join, they come for their issues in court or out of court. Kenya will just join us, fundraise for us, and we will have all the facilities we ever wanted. It will be a success story. Every other person across the globe would fundraise with us, and we'll be there, good to go. A judiciary which is funded, a judiciary which is doing its best, a judiciary which everybody comes to benchmark, a judiciary which is a success story, and that is it. All rid of backlog. 360 days, and there you are. Your matter is finalized.
Thank you, Honorable Judge. You have talked very well and very ably about your strategy for backlog, resolving the issue of backlog. What else in terms of vision? So backlog is one. At least there is one or two other things that you would focus on.
Backlog and technology have to work together. We would have to invest on technology, invest on manpower in that sector, invest on the devices, the materials which are required in technology, so that we are able to advance in that area. We can never go back to the past. To a large degree, I think COVID-19 is a blessing in disguise. We are so advanced now, we cannot go back. So build on that, equip this place technologically. You liaise with people like the Ministry of ICT, the ICT Secretary. You liaise with other experts in that area, CCK, other stakeholders who are in the private sector, and they come up with a well-built ICT sector. This now assists you to get through with the issues of a backlog and other functional essentials of the judiciary. Two, the staffing of the judiciary. I am not sure that we have adequate staffing in this sector. Those are areas that we may have to look at and make sure that we have adequate staff to be able to implement our programs with people who are able, people who are available, people who are willing. The issue of judges is also another very serious factor. Look at this. We are expecting to do excellent, groundbreaking jurisprudence. But you cannot do groundbreaking jurisprudence when you have 30 matters to do, not even 30 is on the lower side. It's 40, 50 matters, judgments and rulings to do within 60 days. So we require additional staff. And that reminds me of the issue of the 41 judges who are still to come here. These ones should be here by like yesterday. We do not have them. What have we done about that? We've gone to court, we've gone blah blah, etc., etc. We talk about it, we shout about it, that kind of thing. I have the background of labor relations and employment, and the background of family law and succession. These are not areas where we must run to court over our issues. We talk and resolve these issues. We conciliate and resolve the issues. We negotiate and resolve the issues. So in the circumstances of our 41 judges, I mean, what options do we have now that we have tried the formal process and it is not yielding results? If it is not yielding results, it is not immediate results. We employ dialogue and diplomacy. If I land in the office of the Chief Justice of the Republic of Kenya in the next 1 month or so, in the second hour of my sitting in that office, CRJ and the Deputy Chief Justice with me in a serious meeting. These are members of the Judicial Service Commission. And what shall we be talking about? It is talking about the judges, the 41 judges. And which direction would I push them? We have, say, matters in court. I'm not even sure of that one. We have a stalemate between ourselves and the executive, particularly His Excellency the President of the Republic of Kenya, Uhuru Kenyatta. So why won't we devise, brainstorm and come up with something to sell to the JESC so that we are able to foment our way forward in this matter towards dialogue, towards diplomacy, towards a resolution of the matter, so that we start from the start point of 200 judges. We have 150 now. With 41, that will be 30 to 200. And that would go a long way in assisting us a clear backlog and make this place functional. So I, the Chief Justice, the CRJ, and the Deputy CRJ, Deputy Chief Justice, have the first session, an hour or two, come up with a strategy or something to present to the JESC. And in the next 2 or 3 days, the JESC is sitting on the matter. In a week, this side of the bargain is done. So we have a formulated strategy for dealing with the approach we are going to use to deal with the matter. Get a meeting with His Excellency. Get a team of 3 or 4 members of the judiciary, of the JESC. Walk down there, have a chat. In less than 4 weeks, that issue would be resolved. And if it is not resolved, we don't close it there. We thrash it further. And within a month, at most 2, we make up our mind as to how to go about it, whether to go to court and pursue it endlessly or whether to strategize differently and get a solution to the issue. Those are the options we have. My choice would be a choice of dialogue, a choice of talking, a choice of conciliation. This is government. And government is not separated. We talk about the robust independence of the judiciary. We talk about constructive interdependence. Government is complementary. The 3 arms of government must complement each other so that we have, the people of Kenya feel the finesse of government. The people of Kenya get the fruits of government. The people of Kenya appreciate that they did not envisage a situation that everybody will be running their own show. Therefore, get a different approach to the issue, go dialogue, go diplomacy. If you don't have adequate people who are versed in diplomacy or in that field, employ them, involve them, get a solution to this matter in at most a month. And I think that is also doable.
Yes, thank you very, very much, Your Honor. I will now request the Commissioner Honorable Acting CJ to ask you further questions.
I thank you. My Lord, let us look at ourselves from within so that we can say where my Lord will take us next. We have an instrument called the SJT, which is our current blueprint. At every page of it, we emphasize bottom-up approaches, strategies, and purpose-driven leadership. That is done with an intention to achieve for ourselves an agile, modern, and responsive judiciary. My Lord, with particular emphasis on our subordinate courts, please give us your conception of purpose-driven leadership, how that can be engendered in our courts, and more particularly the subordinate courts and the tribunals. Please be specific to the area that I have directed my Lord to.
Purpose-driven transformation or systems of getting results intend or would focus on where you have identified what you want to get. The main product we have here is output, dealing with the matters that we have in the magistrates' courts, in the tribunals. So what we would require to do is educate everybody of their place, and within themselves form leadership circles, so that these people are educated on their targets, what we require to achieve from their work. These people are guided on how to do this, lead themselves to achieve the set goals. These people are shown and monitored so that they are able to do that on themselves. We would have supervision from other sectors, but within themselves, this should be emphasized so that we have internalized the leadership in the tribunals. We have internalized the leadership in those so-called subordinate courts. They become their own masters, and they are capable. The differential between those who are in the magistrates' courts, in the tribunals, could be a differential of age. They are trainees, professionals like us. In so little time, they will be our age and dealing with the bigger things. So motivate them, educate them, train them, and give them the steps of leadership, the methodology, etc. When they are educated, when they are trained, when they are shown the way, you lead by example, you demonstrate.
My Lord, may I? Is
Please.
that to suggest that all the things my Lord is talking about now are not in place? That the people we have in the subordinate courts, which is actually our highest constituency, are not equipped in the manner my Lord is suggesting?
I am not suggesting that. I've been to various courts. I've served in various stations. In fact, I'm a Kenyan. Even without being in the judiciary, I would know that they do that. But now we are talking about result-driven leadership, where you emphasize that you do your targets. These people are, are educated. They are shown the importance, because we may have issues now because of things like laxity, things like lack of firmness, things like lack of knowledge. So re-engineer this system, motivate these people, and I believe motivation would go a long way in getting them to do things faster, better, and achieve bigger results. We have them agreed, but we require that they are motivated, they are monitored, they are educated, they are loved.
Thank you, my Lord.
And
thank you.
Thereby we achieve what we wish to do.
Thank you.
Yes.
Ours could be described as an extremely unique institution where judicial officers, who include judges, have some special protection called independence. But my Lord appreciates that independence does not stand alone. Would my Lord please tell us what it stands with and how, as our team leader, my Lord would foster that independence with that other something that I would like my Lord to tell us what it is on the judicial and the administrative function of my Lord, the Chief Justice.
Thank you, my Lord. The history of this of the judiciary has a situation that the issue of independence of the judiciary was overplayed, such that when performance contracting came in some maybe 10 or 20 years ago, it was resisted so badly. We have come to learn that we are accountable, and accountability is a part of our system and our agenda. So we cannot run away from accountability on the pretext of independence. We have an employer. This employer has invested in us, and he must get results. In the first, transformation framework, we laid the grounds for transformation, and this was effective. So in the second phase of the transformation, we had the SJT sustaining the transformation. In this transformation, we put in measures like performance contracting, where every person in the judiciary would be gauged on what he produces. This is accountability, on grounds of accountability, and accountability becomes part and parcel of what we must always emphasize, so that at the end of the day, today, we know what Judge so and so has done. We know what Officer so and so has done. We are able to tell Kenya, or the people, our employer, that this is what we are doing, this is what we have achieved. We have not achieved any better because of A, B, C, D, and E, and therefore, we are accountable to our employer. Kenya must reap results for investment. I have never doubted that, and they would sit in and ensure that every staff of the judiciary, judicial officer included, is accountable. You are able to tell us, this is my bag of goodies I have packed for Kenya.
I thank you, my Lord. There is something we've been doing since 2018, and it is called reorganizing ourselves. The organization review. Would my Lord please discuss what we are doing there, with particular emphasis on the objectives of the reorganization towards enhanced service delivery?
I am not an insider in that kind of...
Yes, my Lord, you are an insider. Would you please discuss that matter? My Lord has been here since 2012, right?
Please repeat the question.
Since 2018, this institution of yours and mine has been undertaking a reorganization review with a view to enhancing service delivery. My Lord, the question we ask is, what have we been doing? Is it achieving the intended purpose. And now that you ask that, I repeat the question. I'll add a rider to it, what my Lord is doing about it.
Service delivery is a must for all of us, and we must do the delivery in an adequate manner. What we have done is enhancement of resources, so that we are able to enhance, to facilitate our staff to deliver. We have also come in with an effective, system of monitoring delivery of service. We are able to monitor performance through the DCRT, through the monthly returns, etc. What we are saying is that we put in place facilities, or we put in place systems which would make us do better in terms of service delivery. We put in trainings which would make our staff, particularly at the level down there, the support staff, be able to facilitate those who are judicial officers or those who are up there to perform. So we have, I cannot complain. We have done so well insofar as delivery of service is concerned. We are able to issue our returns on a daily basis. We are able to record our judgments through Kenya law.
Let's do this, my Lord, if you allow me.
Please.
As my Lord the Chief Justice,
yes,
if God allows that to happen, then you become our team leader.
Yes.
This reorganization starts from the top and goes to the bottom. Remember, my first question was on our bottom-up strategies. How would my Lord the Chief Justice ensure that each one of us in this institution is with everything we are doing?
Firstly, it will require training. Secondly, it will require effective leadership, so that at all levels we have supervisors who are able to get everybody on board. We don't have any loose ends, so that people are just scrambling over nothing. They do not know what they are doing. So leadership is very, very effective. Two, education through training is would be another factor which would facilitate this kind of thing. And like you said, bottom-up approach, so that everybody becomes a leader. We are able to get things moving up and moving down, so that the two approaches, bottom-up and up-bottom, become effective, and thereby we get what we want.
All right, my Lord.
Involve all the stakeholders, involve our staff, so that they become partners in what we are doing.
Thank you, my Lord. Let me first ask a direct question.
Please do.
And then we can have a discussion thereafter. What is our current strategic plan cover? What period does it cover?
I am not aware of that one.
Which means then that my Lord would not know the strategies, particularly the policies that are discussed in the current policy?
I would not.
Thank you, my Lord. Let's go to the next issue, which is this, and flows actually from the first part. You do not have to be aware of what we have put in the current strategic plan for my Lord to know, because you have been heading stations, at least two, Kericho and now Nyeri, to know what administrative gaps we have in the institution. And you, my Lord, if God allows that to be the CJ, you are the person to fill those gaps, with us behind you, of course. But being the team leader, remember, if those of us behind my Lord become too kajuaji, so as I think Kiswahili is part of our national language, we couldn't lead you. You would have to lead us. And then we follow with ideas, we give you our suggestions, which you may or may not accept. So what are those administrative gaps in particular that my Lord would want to see covered, filled, so that we move this institution to the next level?
One, we would require to streamline administrative structures insofar as judicial performance is concerned. What we have now is, for example, in terms of a high court station, is a judge who is presiding, and maybe other judges who are his followers, her followers. In terms of administration, we have everybody in every other sector, HR, ICT, etc., etc. So what we require to factor in is that every sector, firstly, has people who are qualified, people who are experts in that line. What we have now is, for example, in HR, is directorates which are regional. It may be necessary that in the future we have people in every station so that they can be able to address the feelings of the people, the issues of the people in that station. ICT, we have people, particularly now that we are on teams and we will require them. We have people in every station, but sometimes they are not adequate. Like in Nyeri, I see our officer who is at the headquarters, rotating everywhere to
so
go and
the
resolve
first
issues.
one would be to deal with the human resource issues. The next one would be?
Issues of finance. Finance is a very, very critical in performance. We'd have to source funds and facilitate the activities of every other issue or every other matter that we want to partake. The third one would be, like I'm always saying, training of these people, coordinating them. Because one of our biggest issues in the public service, not necessarily even in the judiciary, is that people get disgruntled and you are not working with them. They are there, they come in the morning, they leave in the evening, 3 years they are away, etc., and nothing happens. So how do you monitor this? I started with saying that we should be able to monitor our people, we should be able to motivate them, we should be able to buy them, buy our staff to our side through incentives which are available, and be friends with our staff. That is the biggest resource. Any other factors, finance included, will not make a difference without an allegiance by our members of staff. And when we achieve that, all these other factors come into place. So buy your people, put them in place, motivate them, make them happy. When you make them happy, everything will happen. When you involve finance and resources, when you facilitate them, they'll be able to do what they must do. When you train them, when you streamline the governance patterns, like in the case of, I mentioned the case of the chief magistrate, who is the CEO for every station, or the magistrate in charge, or the judges there with a presiding judge. You create specific roles so that these officers become accountable. Accounting becomes a parameter for performance and for your job and your profession, so that we are able to serve and do Kenya good.
Thank you, my Lord. My Lord, as Chief Justice, would be the chair of the National Council for Law Reporting. What are the functions of the National Council for Law Reporting?
We start with law reporting. It's one of the major functions of the council. The other one is transacting with our judicial officers so that they are on the know by way of information on emerging jurisprudence, the case back system, and other factors like that. When we have a crowd moving a case, it is their duty to broadcast it, to make it known to those who are consumers of that kind of precedent. The law reporting would also be tasked or is tasked with the duty of streamlining law reporting and doing a highlight insofar as the performance of the judiciary is concerned. You remember we said we send our course list to them for broadcast nationally. So it is their duty. Their duty about to broadcast the judiciary and our techniques for performance, the DCRT, etc., to the Kenyan public for purposes of accountability. In that reporting, they are highlighting what we are doing. They are highlighting performance. They are highlighting our daily cues, and thereby we move on and get them to work to achieve those desired results.
Thank you, my Lord. Maybe you could tell us where the National Council of Law Reporting is resident. In what institution is the National Council for Law Reporting?
Their residence is at Milimani Law Courts, Milimani Commercial Courts. That is the one.
Sorry, my Lord. Under whom?
It is under the judiciary.
It is?
It is a parastatal within the judiciary.
Let's discuss this because I think it's important. The law reporting, you and I, my Lord, will agree, is an important aspect of the work we do.
No doubt, my Lord.
As we speak today, it is resident in the office of the Attorney General. It used to be resident here, but it moved.
I am not aware of that one.
Which means my Lord would not know the reasons why it moved and whether in fact that movement was right, whether they should stay there or whether the person they serve isn't the Kenyan public through the judiciary of Kenya.
No doubt the National Council for Law Reporting serves the Kenyan public. It is funded by the Kenyan public, and all its issues and the concerns pertain to the welfare of Kenya. That being the case, I think the departure from is the most direct link, which is the judiciary of the Republic of Kenya, and which would require it more because of the linkages to the other ministry, the Office of the Attorney General, must have been some administrative measure. It was government planning, like we said from the beginning. We are complementary. So if there are any issues which relate to this and which the judiciary feels are not in tandem with its good feelings or with its systems, the way out is to renegotiate.
My Lord, to be fair to all of us,
yes,
my Lord confessed that he does not even know where they are resident, and therefore my Lord would not know the reasons why they moved. And I think we shouldn't continue to discuss that in abstract. We would have to get the real reasons to know why exactly it moved, whether that movement wasn't the right thing, because you could disagree with any statement I make or anybody else makes. But let's make progress here.
Thank you.
Chief Justice Mutunga was JTF. Chief Justice Maraga was SJT. Chief Justice Marete would be?
Mine would be to practicate judiciary transformation. Why would I do that? We are 9 years down the line. The first one was 2012 to 2016. The other one was 2016 to 2021. That is a cumulative 9 years. We cannot go on transforming forever. We should have transformed. So what happens in the circumstances? I learned in the office of the Chief Justice, and first thing I do an evaluation. I cause an evaluation of how far we've gone in the first compartment, Emeritus Chief Justice Mutunga's JTF, Judiciary Transformation Framework, which was merely, basically laying the background. We come to the one for Emeritus David K. Maraga, and we assess now and get an assessment of how far we are insofar as judiciary transformation is concerned. When we are through with that report, it will tell us how to get moving. And my take in this one would be, if we are not through with that, with the transformation, the style of JTF, style of SJT, then we give ourselves strategies to deal with this, but do a practication, because we have this, down. It has been done, it has been started. We now know the percentage of a transformation that we had. So now, practicate this, make it real. How would I do that? I have talked about two stakeholders, the judiciary staff and the Kenyan public. With those two stakeholders happy, if you make the judiciary staff happy, if you make the Kenyan public happy with you, you'll be in good stead to practicate. Because that is number one. If you achieve that, everybody who comes through the corridors of the judiciary leaves happy. This is costless.
All right, my lord. Let's go to something else. And it is this. I noticed from your papers that you have a diploma in theology from the PCA University.
Yes.
And now, from that, I ask this question.
Please do.
How do you relate your moral opinions with your judicial philosophy? Would you associate with the legal theories that emphasize an intersection between the law and morality?
I have done my fair share of jurisprudence. How would I relate who I am as a Christian? Because I have many faces. I'm not merely a Christian. I have my other facets and personalities and persons. So the issue is Christianity vis-a-vis what I do. One, I have come to the judiciary. I am an employee of the jail.
I'm glad you are a Christian. You're in good company. I am a Christian. I like to think I'm fairly good Roman Catholic. But one does not have to be a Christian to do theology. One doesn't have to be. One doesn't have to be a Christian to do a diploma in theology.
Yes.
And so the question is, having done that diploma in theology, how has it prepared you for the work you do? And do you mix theology, religion, morality, and the law?
One, as an officer, like I was saying, I am an employee of the judiciary. Who I am as a Christian is separated from this. Agreed? The School of Law code, the Realist School of Law, says that, states that, opines that a judicial officer would largely, what you see in a judicial officer, or the product of a judicial officer, is who he is in terms of personality, in terms of ideology, in terms of thinking. Good enough. That is a legal theory, and we leave it at that. What do we deal with here on a daily basis? You remember my personality, myself, and my Christianity serve me as such. It's a spectrum of my life which is complete and whole. But I must be able to relate this very, very carefully and cautiously with what I do in other spheres of my life, such that when I come to a place like this one where I have to make a decision, it can guide me, no doubt, because even if you are not a Christian, there is some element of religion in everybody, including African traditional religion, which I suspect is almost dead now, with 130, 140 years of colonialism and post-colonialism. Africa's culture and religions are almost dying. So we are saying that we must be able to separate and draw a distinction between the diploma in theology and your religious faith and what you do. You can relate it to some extent, but to the extent that is palatable and acceptable, not anything beyond that. We were not called upon to come to the judiciary to preach, whatsoever not. We were called upon to the judiciary to come and do that which we are assigned, and do it in decency.
Thank you. If you find a lacuna in law, what would my Lord do?
One, before you make a decision and it is broadcasted, there is the issue of a consultation. You discuss to identify whether indeed what you are seeing is a reality. When you find a lacuna and it is established that it is one,
and you are in the middle of a hearing, my Lord, and you must make a decision in that matter, and my Lord encounters what appears to be a lacuna in the law, what would my Lord do?
You address that.
By what
At
means?
the hearing, if you can, you point it out to the other participants, the litigants, and you look for a middle ground. When you sit down to do your write-up, the ruling or judgment, you would have to point that out. Like I said earlier, this would require consultation amongst your colleagues, so that at the end of the day, you do not, address yourself. You do not clear the lacuna. You do not create your own law and apply it. No. You just note that in the process of hearing, etc., I found out that there is this gap, and you could even point it out to Parliament. As a stakeholder, I would point it out to Parliament and say, this is what I observe. But when you are very, very clear that what you are doing makes sense, when you've consulted adequately throughout your colleagues and agreed that it is an issue which requires address
For-
at any other forum.
Mhm.
Yes.
I want us to get to the Supreme Court, but before we get there, let me just read you this quote from Dawkins, and he says, "There can be no gap in the law. The law is more than rules. It is also about non-rule standards." So that my Lord could reflect on that later. But let's get to my Lord's role as the President of the Supreme Court. My Lord arrives in May and finds 5 of us there already, and my Lord comes with one other judge. My Lord has primarily sat as a single judge, primarily. But when my Lord arrives, finds that this court of necessity sees as a multiple judge court. The bench must have at least a minimum of 5. Okay.
Yes.
Is that an easy thing to do? Is sitting in 5 easy?
It is not.
Why is it not
Particularly
easy?
for the likes of us who have not even had an occasion to sit as 2 or 3. But the argument is countered by the fact that from day one, 16th of October 1980, when we entered the law school up here, we've had interactions with this kind of situations. We've learned, we know. The only thing is that the only difference is that we've not encountered that. 2, we are equal to the task. We can learn. By the time we leave that evening, I'll pick from yourself, the Deputy Chief Justice, or even before we have a session in court, so that we are able to get educated, we are able to get the exposure, we are able to get to know.
That's fine, my Lord. The question is, because I think this is important, let's just spend another 2 minutes on it.
Please.
Is it easy to sit in a multi-judge bench?
It will not be at any one time because of the issue of diversity. The issue of, like you are asking about, your tentacles insofar as religion is concerned, your ideology, your legal philosophy, etc. That diversity is supposed to be an asset, but can also be a liability in the sense that...
in fact, stop there. I'm glad you said an asset, because I want us to discuss that other side. Is it not a good thing to sit in a multi-judge bench, because then your idea is strengthened by the weaknesses or strengths of each of your partners on the bench?
It is good. And
So
particularly,
it's both good and bad?
I am not going to say it is bad. It has all pluses. The only difference and being a liability would come when these people, are not able to agree, and that is allowed. When this disagreement becomes like a part of the problem, and when this disagreement becomes a liability now, or becomes a fetter to the progress of decision making in that court. At all times, this would be an asset, it would be good, there is diversity, there is an exchange of minds, there is, you are able to, interrogate issues and share in a good collegiality. But if this is not the case, if this becomes a problem, if there's no collegiality, if there's no maturity, if there's no tolerance, it becomes a problem. And we can have stalemates, and that will be extremely dangerous. That is not what Kenya has set us here for.
Yeah, but my Lord, it's you who has set yourself up to become Chief Justice. And so you would be telling this commission that even though it is your first time you're going to do this, this is what has prepared you for it, and this is the arsenal. You have to get the 6 of us to work with my Lord the CJ?
Decision making is personal, but we have not even reached there. Day one, we have a matter. When I am new, I will not get to that matter before we have a meeting as the College of Judges in the Supreme Court, so that I am able to learn and know how these things, even the feel itself, that these are the 7 judges of the Court of Appeal, of the Supreme Court. We are sitting together, we are sharing, they are teaching me from the onset so that I become a part and parcel of their team. I would nurture that from the onset so that we don't have any sitting before that is done. And thereafter, we would sit. I would be able to appreciate the issues. I'll be able to relate even more. And in less than no time, in a month, 2 or 3,
Right.
at most 4, we would be partners in progress, equals in the game.
All right. My final question, my Lord.
Please do, and thank you.
What is your most favorite judgment from the Supreme Court, and why is it your most favorite? And I wish you very well, my Lord.
I have had occasion to look at the digest which you issued some 2 or 3 years ago, and I looked at those judgments. The other day when I was preparing for this interview, I came across the Marete judgment. Even without looking at all the other matters on elections and references and everything else, let me come to Marete. Marete is a good judgment in the sense that it has brought us to, in tandem with the current constitutional requirements globally. Murder, death sentence, etc., etc. You talked about religion. I mean, at what time should anybody lose their lives? We are saying that we are on a platform of human rights. We are also agreed as judges and judicial officers. The profession is agreed that more often than not we are making mistakes. So when we do 10 murder cases and hang them, maybe 4 of them could be innocent. Circumstantial things just find them there. Etc., etc. So for a long time, the death sentence has not been acceptable. The death sentence has been overtaken by events in other jurisdictions. So when the Supreme Court came up with a decision that that must be done away in this with in this country, I would say that was a ground breaking.
Thank you. So my Lord likes Marete because the Supreme Court outlawed the death sentence.
Yes, Marete to us is...
Thank you very much, my Lord.
Thank you, my Lord.
Thank you, Chair.
I'm so glad that we had that
brother.
occasion to tete-a-tete over one or two small things.
Brother. Thank you, my brother.
Welcome.
Okay, thank you very much, Your Honor. I will now request Judge Wasame to continue, and the commissioners will restrict ourselves about 30 minutes or less. Thank you.
Okay, thank you, Chair. I'll be brief because my predecessor has asked almost all my questions. Judge, I will ask you 4 issues.
Please do, and thank you so much.
Yes, and 2 of them, you are the one who raised them, about the backlog and how you will resolve it. Now that you are applying to become the Chief Justice of the Republic of Kenya, you must be the leader. And there must be evidence in terms of your productivity that you have been a leader in that area. Isn't it?
Yes, sir.
I have a report from the performance and productivity of the Honorable Mr. Justice D.K. Jagi Marete for the period between 2016 to 2021.
We appreciate.
Yes. During that period, my lord, it says that you handled 3,436 matters. Out of those matters you have handled, you have delivered 73 rulings. Those rulings did not also resolve the cases or close the cases.
Yes.
Again, you delivered 271 judgments. Is that a reflection of Chief Justice Marete?
No, it would be dastardly to have a Chief Justice of that caliber. But I'll go back and answer your question in this manner. In 2018, I was transferred from Kericho. And the ground of my transfer, although it is not stated, was that I had cleared everything that was supposed to clear about the Kericho station. Kericho had a balance of 50 or less files. Eldoret had 800 files. So I made a departure from Kericho to Eldoret and left it judgeless because it would not have been logical to put a judge there. I have my issues on this kind of report. 271 judges in 3 years. I doubt its accuracy because on average, Judge Marete at Kericho he was the sole judge in the station. And on average, Judge Marete would do about 20 judgments. So how would the 20, which is 240 judgments and rulings, on the lower side, how would 20 times 24 times 3 amount to 271 and 73? This is 300 or 350. I doubt that accuracy. Unless there are issues of not transmitting good returns, I'll clearly say with no doubt that is not an accurate report of my performance.
Okay.
And if I do, I would apologize and leave office.
Okay. So if we ask you, for example, to avail your statistics for the period between 2016 to 2021, which is not a reflection of what is before us today, you will be able to do that.
I'll do that with lots of ease. I'll get my dear at Kericho and it will be availed.
Okay. The second issue, my lord, is an issue which you raised yourself about, you said you are a person living with a disability.
Yes, sir.
Is that correct?
It is correct. I am a person living with disability.
Okay. And before you are granted the certificate by the National Council for Persons with a Disability,
yes,
you must have been assessed.
I was assessed.
And
I've even been assessed just the other day in a renewal.
And that your request was approved from the minister downwards.
Yes.
And in your application, you indicated the nature of the disability which you are suffering from.
Yes.
Were you given a card?
I have a card.
You have a card?
It is here.
You have it there?
Yes.
I don't know, the card in your file reads, I don't know whether it is true, my lord, and I apologize if it's not the correct card.
Yes.
It says name DK Njagi Marete. It indicates your registration number, and then it indicates the nature of disability, visual, mental. Is that a reflection of you?
I have a visual disability,
yes,
which has been with me for a long time.
No, I'm asking the second part, my lord.
No, that I have no mental issues. This was an error. I was warned about it by a colleague who is also, a person living with disability. I have never had time to have it addressed.
And this card was given to you, my lord, in 2015.
It was issued to me in 2015.
Yes.
I didn't realize that it was an error. I am diabetic.
No, I am not asking about that, my lord. When did you realize that there was a problem in your card, that there was the issue of mental?
I saw it from day one when the card was issued down there.
Yes.
I didn't think it was an issue because when I went to do my application to the director, persons with disability, I cited two issues. One, I have a visual issue. Two, I am diabetic, and occasionally I get affected by what we call low sugar issues, hypoglycemia. So when they looked at it, they dismissed the second issue as a case of disability. And that is where this error came in. From my record, which was in that original application, the issue of hypoglycemia, diabetic versus, oblique hypoglycemia, was taken or was translated to be mental disability, which will never be the case.
Okay, difficult question. I'm not a doctor. Again, my lord, since you joined the judiciary, you have also been having some personal issues with the registrar, with JSC, about your driver.
Yes.
And I have seen a letter from the principal judge of your court saying that the Honorable Mr. Justice D.K. Marete has been having problems with the drivers since 2014. The last one walked away this week. What is the problem with the drivers?
When we came into the judiciary in 2012, I opted to use drivers who were civilian, not police. There is a Mr. Mwangi whom I had employed myself, and I requested that be employed by the judiciary so that he serves me in the absence of a police driver. I am not able to deal with the police drivers in the sense that I have a very rigid schedule. I do not drive because of my health issues and also my choice. I am not a good driver. So I've always preferred that I have a civilian driver who is flexible and who is able to answer to my needs. So what happened is that my driver was employed in 2013 on contract. When I raised an issue on that one, I was told, good enough, we can let us watch him for 1 year. And when we do that, we'll be able to assess whether he's suitable and material for permanent employment or not. 1 year down the line, on 7th of September 2014, when I was going when I was on my way to Kericho, the contract for this driver, Mr. Peter Mwangi Moria, was terminated. Thereafter, I went on a negotiation mission. The CRJ and Chief Justice Motunga, and we agreed that we would restate Mr. Mwangi so that Mwangi would be paid, and then he does referred to me, and he remains and serves me. Mutunga left. That did not happen. I consulted the CRJ, and we had issues, and she told me that what we are going to do is wait for an opportunity and an advert and get Mwangi to apply so that we can formalize that employment. Well, I was not convinced, but that is not my area. I would not order what happens. So Chief Justice Maraga comes in, and the first week or month I go to see him over the same issue, and I do. And we agree with my Justice Maraga, the CRJ, that the CRJ looks into the matter. And all that time, from the 7th of September 2014, I have been paying my driver. In fact, Mwangi ultimately left in fury because I will not go to tell Mwangi that I am doing this matter for you. I'm negotiating with A, B, C, D, and E for you. That is not good, the best of practices. I was quiet. So we were there, and in year 4, he got tired and left. I got other people. Intermittently, police drivers would come in. So one lasted a day, another lasts a week. The best one lasted about 3 months, and they get very impatient and they take off. Reasons I will not be able to tell, but that is my matter with a driver. From the 7th of September 2014, going to 6 years now, I have not had a driver who is supplied to me by the judiciary. I have paid my driver.
Okay. The second issue, you have been also having the issue of your personal aid, my lord. Is it a matter of concern to the commission?
It is a matter of concern, but when I become Chief Justice and come to Nairobi, it will not be an issue anymore. Why? My issue of hypoglycemia is an issue, a medical issue, which everybody should pay attention to. I cannot live alone whatsoever. So when you take me to Kericho, we have a home in Nairobi and a home at Chuka. When you take me to Kericho, my spouse must accompany me. When I take any safari or any venture for the judiciary, for my employer, which is out of my station, she must accompany me on grounds which are medical. Thank God we will be Chief Justice in so little time. And when we come to Nairobi, we shall not require any of those issues because we shall be home. The issue was when we served outside Nairobi, we will never serve Chuka. It will not work. So if you send us to Chuka and we are there and you agree that we should be at Chuka, we shall not ask for that. But in a true, it was a justice issue. This lady must follow me. Nobody is taking care of her. She has a hope to take care of. She has her own issues. She has her own interests. Why won't you compensate her as my employer? I am entitled to an aid. The only differential is that this aid is so specialized that she must be my spouse. Did I answer or?
Okay, but you have paid some allowance. Since you
The
joined the
disability
judiciary.
allowance, which has persons with the disability allowance, which is now 20,000 shillings, is not supposed to take care of that kind of things.
Yes.
No.
So
That one is an allowance which takes care of basics. Like if I wanted to take a taxi because of my disability, I would pay for that. If Mwangi was not there or my driver was not there and I'm not able to drive, I could hire a driver, etc. It is not, there's a differential between that allowance, which is payable to everybody who is registered with the council and employed by the government or the judiciary, and the issue of aid. If you are not able to see, we will be able to get you somebody who walks you around to your place of work, to your home, and this person would have to be taken care of by your employer. It is the same situation I have. I am not able to live alone. I require somebody who must live with me. My Nazata will be dead in the next 3 days. So what happens? You are moving them out of their jurisdiction. They are home. So if you do, please take care of that because it's part of the employment contract. That is my argument.
Okay.
And I'm saying very succinctly that if it is a Chuka matter where I have a home, if it is a Nairobi matter where I have a home, I would never touch a cent on that ground.
Okay. So if we appoint you, God willing, my Lord, as Chief Justice, but we don't give you Mangi, your driver, and your personal aide, you will transfer the office of the Chief Justice to Chuka.
I am not saying that is what I'm going to do. What I am saying is that if I'm Chief Justice and in Nairobi, the issue of the aid would evaporate entirely. It would only arise if we are moving out of my station to Nanyuki to check on one or two small things, Kisumu, name it, etc., because she would accompany me and be entitled to that which goes with that. But the aid, the employment status, nothing, because she has nothing to lose.
Okay. And lastly, my Lord, this is a small matter. I've also seen another issue which you have been constantly raising is the issue of the security. And from what I saw, you wanted the judiciary to provide security for your Ongata Rongai home, from again in Nyeri where you are working, maybe in Chuka where you are also reside sometimes. So do you want the judiciary also to provide security for your 3 places of abode? If we, as you are writing also, this is one of the documents I saw, you have been writing about that to the CRJ.
I am not sure of that one, but I remember I wrote on security sometimes around 2016, 2017. What had happened is that when we left for Kericho, we left our boy in the house. At the period of seeking security, the young man decided to go solo. He decided to go to hire a place for himself. So we sought security here, and we were even requested to do quarters for these people, and we did. I cannot remember the precise year. It must have been either 2017 or 2016, most likely 2017. But no security came to assist us at Ongata Rongai. So what I did was my public relations with my boy. And 1 year down the line, the place was vacant entirely. For 1 year, nobody guarded it. I thank God for that, for the security which was, divine. So the young man has gotten back. I would not require any security. If you look at my history, I am not very fanciful of issues of security. I can walk anywhere, even as Chief Justice. I have not offended anybody. I have not taken anything from anybody. If you throw a stone to me, you can only be an aggressor. That's my theory of life. I am very, very simple. Simplicity is a hallmark of my life. I have never requested for any security for Chuka. If anybody tells you that, if it is in my writing, let me look at that. I have never requested any security for Nyeri. I have never requested for any security for Kericho. I have never requested for any security for Eldoret. The few months that I lived there, about 2 years, security is not my fancy. Even as Chief Justice, it will not be an issue to me. You might want to force me into it. The government might want to force me into it, but that one we would have to negotiate. I am not insecure whatsoever.
Thank you very much, Judge, and I wish you well.
Thank you, sir.
Honorable Judge, just a small clarification about the card, because you said you just renewed it. There's a new card now. Is that, am I right?
I do not have a new card.
Or is the same one?
I've never had time to go and, have a renewal of this card.
Okay.
Yes, but I was warned about it by those who are experienced in this game.
Thank you, Honorable Judge. I will now request Commissioner Judge Majaja to take you through some questions also. Judge?
Thank you, Chair. Good morning, my Lord.
Good morning, sir. Good morning, my Lord.
Yes, I'll follow up some of the issues that have been raised by my colleagues who have preceded me. The Honorable, the Deputy Chief Justice quoted to you a quote by Ronald Dawkins, one of the leading jurisprudence, about there being no gaps in the law. I want to just give you a situation, and maybe you'll enlighten us on what you do. A couple, Mary and Peter, let's call them Mary and Peter, are in a relationship. And at some point, the relationship breaks down. Peter, one night, goes into Mary's house and rapes her. Then she conceives. And when she realizes she's pregnant, she goes into a deep depression and decides to have an abortion. At about the same time as Peter is charged with rape, he's leaving the court and he's knocked down by a motor vehicle. And unfortunately, he's paralyzed, neck down. When he hears that Mary wants to have an abortion, he comes before you sitting as a judge to restrain her from having an abortion. Applying constitutional principles under the Bill of Rights, how would you attempt to resolve this issue? Maybe you'll tell us briefly.
We have Article 26, the right to life. This one entitles everybody to life. So the attempt by Mary to procure an abortion for the baby or the fetus would be an issue or an obligation, an affront to Article 26, and this would not be a constitutional issue. The right to life is absolute and is an entitlement to every other person. The fetus or the intended baby has that right to life, and therefore should be it should be safeguarded so that we have a natural birth and the baby lives his life. What are the rights of Peter in this matter? Good enough, there was some misunderstanding between Peter and Mary. This is a product of a rape. Does he have any right over that? He does.
And what about the fact that Mary, first of all, she has undergone physical trauma, she has undergone mental trauma as a result of this particular incident, and she says, look, and the doctors have said, if she has this child, she will never be the same. In fact, we will have to take her to Marete. Is that a proper consideration?
It is a proper consideration on medical grounds, on examination or verification by a proper, a qualified medical practitioner. We can the right to abortion is dissipates.
So it is possible that she can have that abortion.
She can have it.
But
if
what about
issues
Peter?
which are threatening her life?
Okay.
And insofar as Peter is concerned, if there's a threat to life, to the life of Mary, and or a threat to her medical position, which deteriorates this life to.
So if Peter is telling you, look, I'm the firstborn in the family. I'm the only son of my father. I cannot have any other children because I'm paralyzed neck down. And let her have this child. I will take care of the child. My parents are willing. Would that change your position?
It would not change my position because these rights must be looked at consecutively. In the sense that, firstly, from the evidence or the facts of the case that you've given us, the most critical person here is Mary. Mary has suffered psychologically on this matter as a consequence of these events. And if we sustain the pregnancy, she might lose so badly that we may not even be able to recognize her. She has a human rights insofar as her life and the enjoyment of it is a concern.
Okay, thank you. Thank you for that answer. I think I'll move on to the next. You have brought us, in your writing samples, you gave us 5 writing samples. One, your dissertation, which I must commend you, under the tutelage of Professor Koth Ogendo.
Thank God.
Yes. Lucky to have been guided by him. Then you have 4 cases and an article. In your dissertation, which is about, it talks about constitutional dispensation in Kenya, the politics of the constitution and the constitution-making process.
Yes.
And I think what we are going through right now is really, this becomes an important topic right now as we are trying to go through the constitution amendment process. And in your paper, you set out 2 hypotheses. The first one is that Kenya is at a crossroads. And you are talking about that particular time. Is at a crossroads.
2005.
Yes, 2005. And you were saying that Kenya is at a crossroads and suffers a constitutional crisis due to past abuse of the constitutional practice by the ruling elite in the entrenchment of parochial self-interests. And 2, that the current constitutional crisis is a consequence of lack of legitimacy arising out of reluctance of the ruling class to incorporate participation of the people of Kenya with a view to accommodating their views and interests in the new constitutional dispensation.
Yes, sir.
When you become the Chief Justice, one of the things you may have to deal with is amendments to the constitutions that affect the judiciary. If you are writing this dissertation in reference to what the proposed amendments are to this constitution, what would be your conclusion?
If we are to make amendments to the constitution touching on the judiciary, our constitution is very, very clear. The issue of public participation must be had before laws, policies, etc., are had in this country. And it is basically a right that we include everybody in the decision making and in our policies and in the way we run government. So if we would have to have constitutional amendments which touch on the judiciary, then the judiciary must be involved. Kenya in entirety must be involved because primarily the judiciary is the property of Kenya. If we are not involved, if Kenya is not involved, we are as a most immediate stakeholder with the people of Kenya, then it becomes unconstitutional, and we would put a case against those who are in charge of the process.
What I want you, my lord,
please,
is you have come in and now you have found the amendments in place.
Yes, sir.
You are part of the KMJA, and we have made our position very clear.
Yes, sir.
We think that these amendments are an affront to the independence of the judiciary. in your first address to the judges, to the magistrates, and to the public, given those amendments, what would you tell the public?
I would tell the public that, one, the staff of the judiciary are not happy with the proposed amendments to the Constitution.
No, they've already taken place. You are now Chief Justice. The amendments are here. How are you assuring us, the JSC, the judiciary, the public, that in fact we are independent?
I'll assure my members of staff and the JSC, because I'll be the chair of the JSC, that we shall take immediate steps to renegotiate the amendments which relate to the judiciary. Because if the amendments are there and it is like final, we cannot close that. Conciliation does not end. We'd have to, if they are not there, if they are offensive to our functions, we will not close there. We will not say that that is enough. We will not say that we are beaten.
Okay.
We would still push it and raise it. If we get to a deadlock and they are not, it is not done, we leave it at that. We are not going to fist cuff.
Okay, thank you very much for the answer. One of the important areas you will deal with as President of the Supreme Court is the presidential election petition. And I'm sure as you came through this interview process, you familiarized yourself with the jurisprudence, the decisions.
Yes, sir.
And there is a decision that came from the East Africa Court of Justice, Martha Wangari Karua versus Attorney General. You are aware of it?
I have, I know it from the general public, the press.
Have you read it?
I have not read it.
Have you read the cases that led to that decision?
I have not. I relied on the material which was distributed to us some 2-3 years ago, the 2013 elections.
So have you read about the election petitions, the issues about jurisdiction?
Yes, I have, sufficiently.
Sufficiently?
Yes.
So the proposed amendment intends to make the Court of Appeal the final court in respect of election petitions. In your view, is that a good thing or a bad thing?
That is a very, very good thing. I have been through some write-ups by people outside the judiciary and even inside the judiciary. I've read your write-up on that book on elections. I've read Chief Justice Maraga's. I've almost virtually gone through that book. And issues are arising on the jurisdiction of the Supreme Court insofar as election petitions are concerned.
So what is the issue about right now in terms of the jurisdiction of the Supreme Court in election petition? Where does this jurisdiction come from?
The jurisdiction of the Supreme Court in this matter, in the matter of elections, arises out of Article 163(4), where the issue of interpretation and application of the Constitution comes in, and the alternative issue, which.
So what is the? Yes, they said that it's an issue of interpretation and application. But what do the critics say about that approach?
The critics are saying this, and they have raised 4 points. Mothomi Thiankoru, who was involved in the Munya 1 and 2 cases, has written a very beautiful article.
Yes, so what are these points? Just tell us the points.
He says, one, there are amendments to the Constitution, to laws, 2013 amendments, did not touch on the Supreme Court. The amendments which touched on elections in 2013 to the law were for the High Court and the Court of Appeal. That's a first pointer that the Parliament did not have any issues, did not envisage a situation that, would not have wanted a situation that the Supreme Court becomes an arbiter in election petitions. That is the first pointer. The second one is the capacity of the Supreme Court. There are 7 judges. We have 67 senators, 47 governors. We have 390 MPs, 1459 MCAs. Would any sensible Parliament have anticipated that or provided that in the Constitution, so not the Parliament, but the constitutional drafters, would they have anticipated a situation that the Supreme Court is able to deal with any leftovers, because leftovers are the appeals over these matters, and they deal with it?
The third point? The third point?
The third one is decisions of the Supreme Court itself before 2013. The decisions of the Supreme Court pre-election pointed out that this is a memento court, which only comes out at moments of constitutional constitutional interpretation, or they call it a constitutional moment. That is when we rise up and answer to this. So if that be the case, then why would it have to shift immediately after the election, so that every other matter which is in the Court of Appeal, etc., would have to get to the Supreme Court? And lastly, Mudhomi Diankolo argues that any looking at the Constitution of Kenya 2010 does not indicate, there's no indication whatsoever that it intended that the Supreme Court becomes a final appellate court in election petitions. If you read the Constitution.
So, if the amendment does not go through, what position would you take?
As the President of the Supreme Court of Kenya, as the Chief Justice of the Republic of Kenya, this is an issue of public controversy. The jurisdiction of the Supreme Court, and particularly relating to election petitions. What would I do? Firstly, call our people, the Supreme Court itself.
Let's put it this way, because you don't discuss, you don't decide cases outside live cases.
Yes.
The court has said we have jurisdiction.
Yes.
What is the reverse point? You would say, if you decide that the court has no jurisdiction, in what instances then would matters of elections come to the court? Because you can say, if the court had not said, elections petitions do not have matters of interpretation and application of the Constitution, in what other way would election petitions reach the Supreme Court?
In my own thinking, supposition, and from what I've read, firstly, I would consult widely, particularly amongst the judges of the Supreme Court, so that we come up with our position on the matter. After coming up with our position on the matter, we would go to other stakeholders, those who bring in these arguments and thrash it out, so that we come up with a concrete position which would act. I am warned that I would not go and bulldoze the judges of the Supreme Court into any position insofar as
yes,
the matter.
It is true you would not bulldoze anyone, but now we are having a discussion. Say, before you come in, the court says an election petition is not a matter of interpretation and application. In what other way would an election petition come to the Supreme Court, other than application and interpretation of the Constitution?
I would be very, very, very vague at personal level.
No, not at personal level. You are the judge.
I'm the Chief Justice.
Yes.
We have the judges sitting and deciding on what to allow in and what not to allow in.
Yes.
Precisely that. In that kind of a circumstance, we would have to scrutinize the matters for constitutionality, because it has been argued that if you wanted to raise this matter and enlarge it, every other activities of our lives are constitutional matters.
Okay, I will leave that for you to digest.
Thank you.
The next point I want to take you through is what my colleague Commissioner Warsame touched on. He talked about your driver. He raised the issue about your drivers. You have explained it. But there's another concern which there is a case here. First of all, you are the Teachers Service Commission.
Yes, 5 years and 70 days.
5 years and 70 days. And you were relieved of your duties there.
Yes.
And you went to court.
I did.
And the court vindicated your
all the time.
Yes, vindicated your position. So, in one of your judgments, this is the case of Professor Misia Manuguti Kadenyi and Masai Mara.
Yeah, the Masai Mara University case.
And this is, it's not anything to do with what you did. It's just I want to put to you a situation which, in that decision, and this is what you said. On this, I wish to rely and take credence on the authority of D.K. Njagi Marete versus Teacher Service Commission, 2013 KLR, where my good friend and brother, Rika J., very ably interrogated this term, and you were talking about termination and retirement, and came out as follows, and then he stated the law.
True.
Now, as a judge, wouldn't this kind of statement worry you that this is you're quoting your own case?
One.
Two, you're saying my good friend and brother Rika J, a case which you succeeded. Wouldn't that worry you?
Good enough. It's a question of expression. One, when I quoted the matter because throughout our jurisprudence in the court in the last 8 years, or any other jurisprudence, I have never had occasion to find anybody who had that succinct and a very good definition of what retirement on public interest is.
Okay.
So it's a matter which fascinated me. In fact, I would give him 1,000%, not 90 or 100. 1,000%. It was beautiful and nice. Okay. On the other issue, we were here in 2011 and 2012, and I learned from the JESC then when we came for the interviews for appointment, the issue of language and talking softly, and I can't remember the term they use. Is it a hard language? I can't remember. But whatever it is.
Yes.
One, I am a student of literature, and I believe in expression.
Yes. The point is, before we go on, the point is, if the Teacher Service Commission were reading this judgment,
yes,
okay, you fought them in court.
Correct.
Now you are referring to the judge as my good friend and brother. What is the perception they would have?
One, a good friend.
Mm-hmm.
There's no possibility. You know, you are my very good friend, good commissioner. We work together. We are in the same station. We are in the same court, the High Court and the Equal State. We are in the same. We are equals. We interrogate when we find occasion, like in the colloquiums, or when we meet in the streets, or in the corridors of the court, etc., etc. I have no enemies whatsoever.
No, the point I'm making is not that you have no enemies, you have friends. But you know, for a third party, this is Teacher Service Commission, they have been in litigation with you, then in a judgment, you're quoting, you say, "Judge, my good friend and brother." Don't you think that's an issue which you ought to reflect on?
It could be an issue
yes.
if you are a simpleton. This is English we are speaking, not the language of the people of Chuka. Even in the language of the people of Chuka, it will be the same. We are saying I have done some descriptive, a reference to, that's what I feel about him.
Okay.
It has nothing whatsoever to do with what he gave me. In that judgment, he clearly tells everybody, the whole world, that in that period that he was dealing with the matter, none of us, Judge Onyango, the principal judge, was the prosecutor. He prosecuted that matter for the...
Okay, thank you for that explanation. I'm satisfied. So I'll just go back to the last issue. In your earlier discussion, and you laid a lot of emphasis on that, you talked about, you really emphasized your relationship with staff, making staff happy, motivated, and being friendly. In this case of Collins Odumba, it was a case for contempt, isn't it?
Yes.
And the accused there was a member of staff.
No doubt.
Was a member of staff.
Yes.
Now, one of the complaints I have had, and this has been mentioned to me, is that the staff accuse you of being high-handed and heavy-handed. High-handed and heavy-handed. So this was a case where, and if I may just read for you, you say, on the morning of 27th, we were treated to a now commonplace spectacle during proceedings in court. In the middle of the first phase, there were loud, continuous noises heard from outside the courtroom. It was clear that this was a chat between two persons, and the volume and continuity of that noise forced the court to stop its proceedings, as this was not possible or practical. So there was noise in the court, isn't it?
Yes,
and
on the corridors.
On the corridors, and you were unable to proceed.
Correct.
You then went and inquired, who is this making noise? Sent your clerk, find this person.
Bring him in.
Bring him in. Okay. A lot of things happened between, and he was finally charged with contempt. In fact, you said on 30th, this was on 27th, you realized the accused on 30th, this is from your own writing, on 30th May 2016, the accused, who I now realized was a court staff or officer, was brought to court at around 11 hours. 100. What I want to ask you is this. We know contempt is a very serious issue.
No doubt.
Yes. And in fact, you recognize that in your decision.
Yes.
But this is a member of staff.
Yes.
Is a member of staff.
Yes.
Surely, weren't there mechanisms within that station you could use to deal with this particular issue?
If you read the ruling, clearly, you'll appreciate that this was not a one-day matter. This matter had continued for well over 6 months. We addressed issues of people making noise in the corridors, day in, day out, etc., etc., etc. And we had even the chief magistrate, now Judge Ongondo, had taken steps, plus my dear Mr. Ndoruri, had taken steps to fight this menace, but it would not go away. For a long, long time, we have this issue, and it is not going away. For a long, long time, we have, the cells down there, and there's noise, and it is refusing to go away. We cannot sustain this. So on this day, On this day, we heard the noise. People are chatting in the corridors, and the court is continuing, and we call for the officer. We call for the persons who are making the noise. One is brought in. In fact, there were two members of staff. One is brought in. The other one says nothing. I am not heeding to that call. What choices did we have? What I did was stop the court and defer proceedings and deal with the matter. How did I deal with it? I got the person arrested and brought it to court. When he was brought to court, he was so panicky, etc., and I said, put him in. We have no time. We can deal with him on a different date, on a Monday. We resumed the court.
Okay.
That is the circumstances under which we dealt with that matter.
Okay.
The nuisance had been continuous for a long time, and we suspected that it could even have been deliberate and political.
Okay.
Otherwise, how are we able to deal with noise day in, day out, 1 week, 2 weeks, 3 weeks, etc.?
In fact,
those are the circumstances in which we found ourselves, and we had to be firm. High-heartedness and firmness are two different things. I have never boxed any of my officers. In fact, my officers are very, very happy with me. Where you get this kind of reports, good commissioner, I would not know. But when you get that kind of report in the future, even when I am Chief Justice, get that person.
So at the end of the day, would you now you are the Chief Justice tomorrow? Maybe you are the Chief Justice tomorrow. Are you telling staff that in fact the criminal law will be brought to bear to them for any infraction? That they should fear you because you are the Chief Justice who resorts to the criminal law in order to resolve problems in administration. Is that something you want to tell them, to reassure them?
That is not the message. This was an exceptional case and a last resort. If we had not taken that kind of step, administration had been there. We have a DR, we have a chief magistrate,
in fact,
we have a presiding judge, and this issue had been, they had handled these matters, and they were not coming to there was no solution. Particularly when the officer now, one officer comes to court and sits there with us so that we interrogate the issue of noise.
Okay,
the other one doesn't, that refuses flatly. Yes. How would you deal with that?
In fact, in your judgment, you say this issue has variously this is your own words, reported to the judicial officer in charge of the station, but to no avail. So you had reported to the station.
Yes.
And you even asked, who is in charge here? The Chief Administrative Officer, Rate CEO of Kericho Law Courts, is the Senior Principal Magistrate, one, George Ongondo, that is now our colleague in the Superior Court. What tale of expedient court administration does this portray? What are our levels of leadership in this sector? One thing I want to ask you, were you a member of the LMT in Kericho?
I was.
You were. Was this issue raised?
It died with the prosecution or the litigation of that matter.
No, prior to the prosecution, was it raised?
It never featured as a matter for discussion in the LMT.
Yes, it never. So you were aggrieved many times that this is an issue of noise. You attended the LMT, never raised it. Thought it was serious enough, started contempt proceedings before yourself, and then in your own judgment, you indict the leadership of Kericho. So what I'm just asking, should the staff, judicial officers, heads of station have faith in you as the leader to lead this judiciary?
My answer is loud and very, very clear. Everybody is entitled to their feelings on any matter. we cannot take away that right. It is indivisible and a human right. The staff of the judiciary would have to have their own assessment, have their own feelings about me, etc., etc., etc. I have my position, and I will assure you, Commissioner and my Lord, that we cannot lead without firmness. You'll not get anywhere. You'll not get any results. You have to be firm in what you do so as to be able to establish, to get results, to establish your policy, to establish your work ethics, your standards.
Okay, thank you very much, my Lord, and wish you well.
Thank you.
Okay, thank you very much, Honorable Judge. We will have a short break. But before we do that, Honorable Judge, we must observe the constitutional requirement regarding diversity, so which is your county. Is it Meru?
No, I'm not from Meru. I never was from Meru. In that great Meru, we were just sojourners.
Okay.
And peripheral.
All right.
I come from Tharaka Nithi.
Tharaka Nithi?
Yes.
Thank you. And ethnicity, Judge?
I am Chuka.
Chuka.
Yes.
Thank you very much. And then there's a request, Your Honor, that the card that you have, we would like to see it, just to compare it with the card with Judge Wasame, so the CRJ will pick it from you, Your Honor. And you have 10 minutes break. We come back at 11:20.
Thank you. Good chair.
Thank you. So, Commissioners, we can take a break for 10 minutes.